Start. Sri Misra contends that the said regulation in relation to extension of the period of probation requires recording of reasons in writing by the appointing authority. Stop. He therefore submits that in a lesser adverse situation where the period of probation is to be extended, the regulation provides for recording of reasons. Stop. Therefore, while discharging a probationer, such recording of reasons are all the more necessary as discharge is a harsher measure than extension of probation. Stop. For this, the guidelines are provided in Regulation 46(5), where the satisfaction has to be recorded by indicating as to whether the work and conduct of an employee is satisfactory or not. Stop. In addition thereto, the requirement is certification of integrity, and the third criteria is that the appointing authority should be satisfied that the employee has otherwise successfully and satisfactorily completed his period of probation. Stop. Dr. Misra contends that there is only one recital in the communication that the work and conduct was not found to be satisfactory. Stop. He submits that this recital in the communication is not borne out from any such endorsement or expressed opinion having been recorded by the appointing authority. Stop. He contends that on the submission of a report for approval, the appointing authority has to be independently apply his mind and record his satisfaction may be in a very few words to maintain brevity. Stop. In the instant case, the appointing authority has not even chosen to do that and has simply put his initials. Stop. He, therefore, submits that regulation 46 has not been complied with, and the judgment relied on by the learned counsel for the respondents had only an endorsement of signatures certifying approval cannot be a ratio applicable in the present case, as there is a different statutory provision with a clear requirement of recording satisfaction. Stop. Para. Before we proceed to deal with the aforesaid submission of Dr. Misra, it would be apt to comment upon the status of the records as indicated above. Stop. We find that letter of the head of the department had dated 2/5/2015 in relation to appraisal of performance for the period of probation recites that the integrity of the petitioner was poor, and this letter finds mention in the report dated 29/5/2015 submitted by the director for approval that has been countersigned with the initials of the president. Stop. In our considered opinion, if this is treated to be a occurrence concurrence, then it also certifies concurring with the endorsement of a poor integrity of the petitioner in the letter dated 2/5/2015. Stop. However, at the same time, the simultaneous proceedings relating to the endorsement in the ACR, the head of the department endorses the column of integrity as having not been tested. Stop. This ACR is also tested by the reviewing authority on 27/5/2015 and is concerned expressly by the president, who is the appointing authority, on 1/6/2015, which is the same date on which he has put his initials on the probation report dated 29/5/2015. Stop.